any other recourses available if the United States Supreme Court declares a law unconstitutional?
One of the things that the legislative branch in particular can do is what we can see after the case of Lopez v. United States. In this, they declared the Gun-Free School Zones Act unconstitutional. However, Congress simply made a small change to the act and was able to pass it, and we currently do have a Gun-Free School Zones Act as a nationwide law.
Are there any other examples that the panel can cite?
We can also see that they can pass an amendment. So specifically, the 13th and 14th Amendment overturned the Dred Scott decision, and so this is another check against judicial power by the legislative branch.
Okay, so the Constitution does not mention judicial review specifically. How and why has it become accepted?
Article 3 in the Constitution states that the judicial power of the United States shall be vested in one Supreme Court. While it does not specifically delineate judicial review, it implements what judicial powers there are in the Constitution.
Judicial review is not a new idea. If we look back to English common law and with William Blackstone, essentially judicial review was seen within his English common law.
We can see when the first arguments of judicial review can be seen within the Federalist and Anti-Federalist debate. Specifically within Federalist 78, they argued for the importance of judicial review to interpret the Constitution, and in Buddhist 5, the possible downfalls of that.
Additionally, the 1803 case, Marbury v. Madison, ruled the Judiciary Act of 1789 unconstitutional, which severely, in theory, limited the court power. But through this, they set precedent that created judicial review as we see it today, even though there were cases prior to Marbury v. Madison, like Hilton v. U.S., that were not very controversial. This was the case that set precedent.
You touched upon it in your opening statement, but can you expand on how the concept of judicial review is related to the concept of checks and balances?
Judicial review is checked internally through the congressional legislation that requires 9 Supreme Court justices. So not one Supreme Court justice can make a decision that will overturn the others. We need a majority decision.
We can also see that previous to judicial review, previous to the case of Marbury v. Madison, the judicial branch was much weaker than the other two branches. By giving through Marbury v. Madison and setting the precedent for judicial review, it now has a substantial check against the executive and legislative branches, as well as the states.
Another check on the judiciary system is that the president must appoint the justices. However, there must be hearing heard by the Congress to determine if that justice shall be a seat on the Supreme Court.
There are also internal checks in the judicial branch. It's called a recuse, where a judicial member may step down from the bench during a certain case. Elena Kagan, in a 9-month period, sat out of 28 cases out of 78 cases. They believed that this would have a split decision 4-4 going to a lower court, but this did not happen.
You spoke of the controversy over lifetime appointments of federal judges. Do you believe that elected judges would be any less controversial?
With elected judges, then they are more elected by the people, which is representative for small communities like our state, or such as the Nevada court.
seamless in your written testimony.